Welcome back to the Family Building Podcast. We're here again with attorney Danielle Augustin, and we're talking about special education advocacy. In the first session, Danielle kind of laid out um, maybe an eye-opening kind of awareness for me, an epiphany that wow, I have rights to advocate for my son or my daughter in the educational system, and there's things that the educational system can pay for, and our kids don't have to suffer throughout their educational. Really, it's a foundation stone for the rest of their life. And so, Danielle, I know that you have a special announcement. You have a great passion for this. You know, you're just one lawyer here in Anaheim Hills, California, advocating. I know you're a busy law office, but you want to spread the good news. So, you want to tell us about the new launch that you're doing?
Sure. I created a special education advocacy system for parents. It's a step by step guide to walk parents from the very beginning of special education, including how to find a child eligible, how to get organized, how to read assessments, how to participate in an IEP meeting and understand what comes with an IEP, including goals, present levels, services, accommodations, placement, all of that. And I also walk families through when things don't go as they should, where they don't agree with maybe the assessment, and parents don't really understand. You don't have to agree with everything that the district does in an IEP. You have rights. And one of those rights is you can ask for an independent educational evaluation. I go through that. It's a private assessment by a third party who doesn't work for the district, paid for by the district. And there's also parents have the right to go through due process, which is to file an action, usually with the state agency, the state educational agency, where they disagree with the district. And it's a process where you end up in resolution session, where you start trying to work through the concerns to come to an agreement. If that doesn't resolve the matter, going through mediation, where you have here in California an administrative law judge who helps bring the parties together and hopefully to a settlement agreement. Mediation is incredibly powerful. If you look at the stats in California, about 95+% of cases will resolve very fairly through the mediation phase. I also walk through the families through this course through how to work through a settlement agreement, how to write a settlement agreement, what to look for in those agreements to make sure that the language is fair and can be enforceable. And what I found is that, and the reason I wrote this course is that many parents don't have the ability to hire an attorney, whether it's, financially or this area is so nuanced. There are not a lot of attorneys in this area, so they can't find an attorney. And so I purposely created this course so it could be affordable. And we've priced it less than 1 hour of my billable time. So instead of them paying tens of thousands of dollars to hire an attorney to file a due process case against a district or attend IEP meetings and advocate, I created this course to allow parents to advocate for their children just like I would. I give them all the tips and tools that I've learned over the last 23 years of practicing in this area. And I educate parents on how to become advocates for their children to obtain the appropriate supports and services their children are entitled to receive.
So, Danielle, let's take a hypothetical. Thank you. I think this is really exciting. You know, one thought that went through my head as you were just speaking was, why don't we get an information packet like this from the Department of Education when we enroll our kids in public schools? I don't think they're producing this information and telling us what our rights are and how it is you take advantage of what our tax dollars are paying for, right? So this isn't published anywhere that you can go out and readily access. Is that correct?
CDE, California Department of Ed, and I assume every other state is, if you were to go to their website, you would find all of their rights. Parents would find all of their rights on the California Department of Ed here in California and any other state. However, when you enroll in a child in school, you're typically not going to be given your special education rights unless you're already in special education. So the law is actually very clear. There are several situations where a school district is required to provide written procedural safeguards to families. So, one example is when a family requests an assessment, they have to be provided their procedural safeguards. Those procedural safeguards are very lengthy. They're sometimes 20, 30, 40 pages long, small font, hard to read, and hard to understand. So, although at multiple stages, school districts are required to give those rights, it's not for every student once they're enrolled. It's after they're requesting an assessment or they're going to an IEP meeting. At IEP meetings, they have to be provided those. But by the time you're at an IEP meeting and they hand you a 40-page document and said, here's all your rights. Do you have any questions? I mean, parents are completely overwhelmed at that point. They're not going to sit down and go, hold on, let me read this document for 40 pages so I can understand my rights, which is why they're required to give them along the way. But no, parents, when they typically enroll a student, are not provided those. So it creates a lot of confusion and a lot of families get completely overwhelmed by the process. When a parent walks into an IEP meeting, they're sometimes staring at 10 professionals, looking at them with hundreds of pages of documents for the first time, expected to take all that information in and make lifelong decisions, basically decisions that are going to affect this child for the rest of their life in that moment. So that's part of what cover in the course is really being prepared for these IEP meetings. Families don't realize this. Parents don't realize this. Parents are equal IEP team members. Many families walk in and they think we're going to be told what the school's going to do. That's not how it is supposed to work. You come to the table as an equal member to make decisions for that child. And that's really important. Parents need to come with that in mind, prepared. I also tell families request the assessments 3 days before the IEP so you can read them before you walk into that meeting. I also request for my clients and advise clients in my students in the advocacy system to request to audio record IEP meetings. In California, you can do that with 24 hours written notice. This creates a transcript of what happened. So all of these little things, these are just getting you started right in the IEP process when it's beginning, are so powerful and can change the dynamic when parents fully understand their rights.
Danielle, do you see in your practice pushback from the various schools or various school districts on these rights? And is it a burden to them? Is it, oh, they're rolling their eyes? Who's another parent that's now pushing us to do more work, and we're already busy enough? Do you see that kind of pushback or bias?
I get a lot of clients when they come to my firm for representation, and many of them experience that. They feel like they're being brushed off, or they're not being listened to. And there's a disagreement over whatever it is placement, assessment, a type of service, goals, or a lack of progress, where the school might say the child's making progress and the family's like saying, we're not seeing it. When we step in, what I've noticed is that, and a lot of families get a little nervous about bringing in attorneys, which is another reason I wrote this course is to give them the skills themselves so they don't have to bring in an attorney. But what I've noticed is when I do step in, it really, I think it gives a level of respect. And I don't usually get a pushback from the district where they're disrespectful to me, they're disrespectful to the family. If anything, they come to the table like, okay, let's get to work and let's really come to find a middle ground or come to an agreement that's appropriate for this child. Um, but I think before coming to our firm, they do experience a lot of frustration. They get overwhelmed. They feel like they're not being listened to. And trust me, not every school, not every district is doing it wrong. I've learned some of the best tips and tools and ways to write goals or write an IEP from some pretty outstanding teachers and professionals. So this isn't about being confrontational with the district. This isn't about litigation. This is about the child and what the child is entitled to receive and giving parents the tools that so they can understand the system and they can get what's appropriate for their child and advocating for them in an appropriate way.
So how do they get in touch with this system, which you're just launching here in the month of April 2026? How do they get in touch with this course, Danielle?
Well, We're launching on April 22nd, and they can go to our website, which is specialeducationadvocacysystem.com. And starting on April 22nd, they'll be able to actually purchase the program. And it's 27 modules. And as I mentioned earlier, it covers everything from the beginning all the way through a due process complaint and mediation and everything in between. The 27 modules have 50 videos of me giving teaching lessons in each of those videos. And there are also written lessons, 50 written lessons. And I've also included about 120 downloadable tools and templates for them to use. So, for example, quite a few templates where I've created a template, for example, for them to request an assessment, request an independent educational evaluation, or ask for a specific change to the IEP. I've kind of done the work for them. They can fill in their child's name and I put it in Word format and they can send it off to the district. I've also included a lot of PDF charts that might help them. What's the difference between accommodations and modifications? What's the continuum of placement options? The law says that kids are entitled to the least restrictive environment. What does that mean? I go through the whole spectrum of from general ed to special education to non public school to residential. And I go through all of that and give them those tools. There's also so many acronyms in special education. I have an acronym list that helps parents understand exactly what people are talking about when they're sitting across the table from professionals and they're talking in acronyms and they're like, what is going on? I don't understand this. And so I have this little sheet defines what everything is and helps them in that way. So it's a real comprehensive program. And we'll be launching that on the 22nd. They can buy it at the website. I also have an Instagram, DanielleAugustin.esq, and I post some IEP tips, and they'll be able to get more information about the system when it's launching when they go to that profile.
So although we're sitting in California, this is usable across the nation. Is that correct?
Right, because it's an educational forum, I'm practiced licensed to practice law in California. So this isn't legal representation. This system is for me to educate families so they can advocate for their own children. So that's why the beauty of this is that I can provide this nationwide, which is super exciting to me.
And is it a similar system, Danielle, in say Maryland or Georgia as it is here in California in terms of how this advocacy would play itself out with your child?
Yes, the way I wrote the course is based on federal law. And throughout the course, I will give examples, and I typically give examples of California laws that has specific nuances. But the federal law is the minimum of what all states and all school districts throughout the United States must provide. Now, state law can have more nuanced supports. They can't take any rights away from the federal, they can add to it. They might have different timelines. So, for example, in California, if you ask for an assessment plan, like I said, they have to provide it to you within 15 days or a prior written notice why they're not handing it to you or why they won't provide you an assessment plan. Once an assessment plan is signed, the district has 60 days to conduct those assessments and hold an IEP meeting. Those timelines might vary slightly state to state, but generally, federal law is very clear and very consistent across the nation.
Well, if let's assume that we had a child who was on the spectrum. The child is autistic. We know these. We see these characteristics in the child. There's a diagnosis. The child is going in this last, say, 2 minutes or so. Danielle, give us an example of how you would be advocating, knowing what you know now, or if someone were to read your entire system and course. When would that advocacy start, and how would you direct us, someone, a family with that scenario?
Well, as I mentioned earlier, school districts are responsible starting at the age of 3 for children who may require specialized academic instruction or an IEP. And so I always say about 90 days before their third birthday, if they're already seeing those concerns, to write a letter to the district, put in writing the concerns and request an assessment plan. That would be the first step. If they're already in school, the district has the mandated obligation to seek and find the children. But if they're not, that's when parents can step in and similarly put a request in writing. These are the concerns we have. We would like this child to be evaluated in the following areas and be very specific about that. Could be behavior, it could be in the area of autism, it could be the psychoeducational assessment, but maybe there's speech and language or social skills concerns where a speech and language pathologist would need to do an assessment. As I talked about earlier, the like occupational therapy assessment due to fine motor or other deficits like sensory processing. So, to make sure that those assessments are in all areas of unique need, to be very clear in that request, all of the assessments they're seeking. There are 13 eligibility categories under federal law for a child to qualify. You can qualify under all you need is one, and that gets you in the door to an IEP. Many students qualify for more than one eligibility criteria. It's not necessary, but every area where the child is eligible should be documented on the IEP. Although the eligibility category, for example, autism is one of the 13, is not going to have, it won't have any impact on services. So whether or not you qualify under specific learning disability or autism, it doesn't matter the eligibility, it's your unique needs. So whatever goals that child has, in order to meet those goals, that child will be given services despite the eligibility, despite the diagnosis. You can have children who have no diagnosis of autism, but qualify under autism. You can have a child who does does have a diagnosis, but doesn't qualify under autism. So it's based on an educational model and based on their unique needs.
In a perfect world, if you are on the front end of this and you're advocating effectively in cases, success stories that you've seen, you can imagine then that the child's going to get access to a lot more therapies, a lot more assistance, maybe at school, and this child is going to have a better educational experience. And all of those services may, in fact, be paid for by the government. Is that correct?
Yes, absolutely. They're required to be paid for by the school district due to federal funding. So as we talked about earlier, if parents are finding themselves funding private services, that's a red flag. They should not be funding private services. Now, they have every right to do that, but if the child is struggling in school, and that's the reason they're funding those services, and the child is not being provided appropriate services in that IEP, again, red flag. They should be reaching out to the district, and that they could possibly be entitled to reimbursement at that point.
And one last question. If your child is in private school and you see these same diagnoses or the same struggles, you don't have the same rights in a private school setting as you do with the public school. What would you suggest to those parents?
There, as you just said, you are correct. There's no entitlement to a FAPE, free appropriate public education, for a student who's attending a private school. So you wouldn't be able to. There's a private school has no obligation to hold an IEP, but a school district does. So this gets very layered. But what I sometimes see is students are struggling in the public school. I get a call from parents who are seeking legal representation because they've been funding private school for 2 years because this child was struggling in the public school. So in that situation, we evaluate the case to determine whether or not there's been a denial of FAPE and whether or not that child is whether or not that family is entitled to reimbursement for that private placement. That's a very common remedy that we seek through a due process complaint. Another thing that's really important for parents to understand is even if a child is placed in a private school, the school where the family lives or it depends on the situation, but they're still entitled to a FAPE by the school district. So even if they're attending a private school, I always advise them to ask the school district to assess, even though they're attending a private school. And then the family could then maybe make a decision on, well, should I bring them back to the public school so they can get more supports and services that are not offered in a private school? So there's a lot of nuances, but even if they are placed in a private school, they can still go to their public school and ask for them to conduct assessments and then get an offer of FAPE in an IEP and then make a decision on should we re-enroll in the district, but they're not entitled to an IEP at a private school.
Well, Danielle, this has been very enlightening, and I hope your system, your special education advocacy system, which people can find at specialeducationadvocacysystem.com. I hope it is world changing. We see you as a world changer in your advocacy for children, and we hope this good news spreads. It's been an honor and a privilege to have you on the podcast, and I hope our audience has shifted in their thinking. So thank you very much, Danielle.
Thank you, Ted. I really appreciate you having me on today.
Okay, we'll see you on the next podcast. Take care.
All right. You too.